right, good afternoon, everyone. Welcome back to the Judicial Proceedings Committee. Today's Thursday, April 9th, 2026. We're going to do some concur, not concurs, and then we're going to move on to voting list number 24. So, Jamie, I believe you have the first concur.
Let's start with Senate Bill 475. This is Criminal Procedure, Evidence Protecting Artists, Creative Expression, or the PACE Act. Senate Bill 475 prohibits the creative expression of a defendant or respondent from being admitted against the defendant or respondent in a criminal or juvenile proceeding unless the court makes specified findings. The bill does not preclude the admission of creative expression in juvenile cases for the purposes of evaluating, recommending, or ordering referral to mental health services or diversion programs. The House put amendments on the bill. The amendments actually conform the bill to the House cross-file. It provides that, in part, in any criminal proceeding, juvenile proceeding, or criminal proceeding or juvenile proceeding, the creative expression of a defendant or respondent is not admissible against the defendant or respondent unless the court finds by a preponderance of the evidence that, and I'll just read the new House language, there would need to be a close temporal and factual nexus between the creative expression and the alleged offense. The creative expression is relevant to a disputed issue of fact, and the probative value of the creative expression outweighs its prejudicial effect. There are other factors as well, but that's the substance of the new House language.
So, say concur.
Amended on was, the language that was amended on was to capture what was in one of the case, so I'm fine with that.
All right, there's a motion to concur. Senator Love.
Thank you, Mr. Chair. If the sponsor is fine, then I'm fine. I just have a question. Do we know why they took out the creative expression refers to the specific facts of the alleged offense?
I can try to find that answer out for you. I'll try to find out.
I spoke to Marlon. I'm guessing here. His indication to me was that they were trying to closely align their wording with the wording of the judge in the case. And so my sense is that the court may not have said the phrase, the creative expression refers to the specific facts of the alleged offenses, and instead utilized the language that's replacing that language. I'm speculating.
No, that's what he said. No,
That's right. That sounds right.
All right, so the motion is to concur. It's been seconded. Is everyone okay? All right, Senator McKay's down. Jamie, do you have the next concur?
I do. So this is Senate Bill 514. Senate Bill 514 establishes the offense of misdemeanor assault in the third degree. It specifies that the district court has exclusive original jurisdiction over third degree assault cases, specifies that a person convicted of an assault in the third degree is subject to imprisonment for up to 90 days and or a maximum fine of $500, and authorizes the expungement of a conviction for assault in the third degree. The House amendments conformed they conformed the bill to the language that was in the House, although they did include they retained the provision in the Senate bill that pertained to district court commissioners and warrants. So just to sort of refresh the committee, there was a disagreement in the language between the House bill and the Senate bill about the exclusion from the term offensive contact. If you're looking at the reprint, this would be on bill page 2 of 8. And in the Senate version, provided that offensive contact would not include an act committed against a person eligible for relief as defined in 4501 of the Family Law article. In the House version, and this mirrors the language in the House bill, it would be an act against a person who would be eligible to file a petition for relief from abuse against the defendant under Title IV, Subtitle 5, so that is the protective order statute, based on the facts alleged in the application for a statement of charges. So it was more fact-specific to the case than it was to would fewer cases, was it more narrow? I guess, yeah, fewer cases would be excluded from offensive contact.
Not that it's material, but I just think it's so odd that the balance is being struck, that we are taking away the choice from people who would be eligible for a protective order to seek the charge of third-degree assault. And we are making a policy decision that they don't have the option to do that. These are folks who are in intimate partner relationships, who are in familial relationships. You're related to someone by blood, marriage, or adoption. You have children in common. And perhaps people who do have those longstanding connections one to another would like to have the opportunity to have a lesser charge as opposed to the greater charge with the greater penalty when you are in a longstanding relationship with someone. And we have, I don't know what reason we have, but we have decided that we will take that option away from them and only them. People who we wanted to protect in some context, we will decide that they don't have the ability to decide for themselves between a third-degree offense or a second-degree offense. It feels incredibly paternalistic, and it just feels so wrong that they would be the only people excluded at law from being able to make this determination for themselves. So I don't understand that.
I just want to clarify, my staff just brought me this, so I assume this wasn't on a voting list because they're pretty good at making sure I have stuff in front of me. Yes, I know, but that's still voting, still deciding. So I'm looking, I just want to understand, I have an amendment that's like 393020/1. So is that the difference now? Is that the language that
Sure.
Yeah,
Sure,
I
just-
would have understood this if I had been able to know what we were going to talk about.
So if you're looking in the floor system, so the amendment number that you just read, Senator, was 393020 220/1.
Yes.
Those were the Judicial Proceedings Committee amendments.
Oh.
So that's what JPR did before the Senate passed the bill.
Okay.
If the House Judiciary Committee amendments are numbered 713123/1.
And so, yeah, and so thank you. Senator Solon just showed me that that's this area of lines 18 through, is all of this the amendment?
She's looking on the reprint. I think it's third reader House bill is where I got her.
And that's the lines like 21, is that what I should be looking at?
It's page 2.
Okay.
Hold on, I didn't pull that up. Yeah, the reprint, that's where
Yeah,
we're on.
yeah, that's
We're on the
what-
third reader reprint, page 2
Two.
of 7,
Thank you.
line 18 down through. That
Okay.
Is the language, Senator, should be shown up as that offensive contact does not include
Yeah.
an act against a person who would be eligible to file a petition for relief.
That's the key.
Right.
That's the key.
right.
Eligible for
And
relief as defined.
That reads as being more situation-based. It's fact-specific to the specific case because it needs to be based on the facts alleged in an application for a statement of charges. The Senate version focused more on the relationship of the parties generally.
Right. So, okay, so we're deciding whether we want to concur with that language. Okay, I know where I am on that. I don't want to agree with that. I would like to stick with what we did. That's be my position.
All right, so the motion not to concur. Second, is everyone okay with that? All right, sound good?
Would you like to appoint a conference?
Yeah, let's do. Yeah, we'll do it, I'll do it later in a second. Yeah. All right, do we have one more concur, not concur?
We have two more.
Just, Sandy, can you explain why that's not on? Who's got the next? Conflicts because we just said that we added the piece that the commissioners can't issue a warrant on this one. But if the other bill, I think, does away with that practice altogether. So I don't think they're in conflict with each other, but yeah.
trying to think out loud.
Sure, 140. Sorry. Senate Bill 140 is criminal law benefits exploitation. This bill prohibits a person from committing the crime of benefits exploitation, and the bill establishes graduated penalties depending on the aggregate value of the money or other goods or services involved. The Senate version, the House amendments actually conformed the bill to the House cross file. They did strike some language in page 4 of the bill. Unfortunately, it doesn't look like an official reprint is available in the reprint system. But if you're looking at the bill, as amended by the Senate. Those changes affect just the terminology that's being used in the graduated penalty section. It's conforming language. As it was passed out, it based the penalties on the value of the money or other goods or services at issue, and this changes that to the value of the government benefits involved.
It sounds all right. Probably because we're talking about expropriation of exploitation of government benefits. So it probably is a better way to describe it than money or other goods or services involved. Motion to concur.
Second, is everyone okay with the concurrence? All right, excellent. All right. Shamar, are you in the next one?
Nope.
Josh, let's rock and roll.
Senate Bill 61, as passed by the Senate, establishes the Volunteer Services Program and the Division of Correction for the purpose of providing access to volunteers to assist incarcerated individuals with release preparation. The House amendments made the bill identical to the cross-file, which has already passed through the Senate, by altering provisions related to the public disclosure of the names of volunteers. So I think the motion would be to concur.
Motion's concur. It's been seconded. Is everyone okay with the concurrence? Excellent. Is that it?
We have one more. Josh has one more.
Senate Bill 487, as passed by the Senate, authorizes the State Highway Administration to implement a program of safety corridor speed monitoring systems for use in areas determined to be of high risk to vulnerable road users. So the virtual cross-file to this bill is, I know it's on the voting list today, with amendments that would make it identical to Senate Bill 487 as is before you. The House amendments added a provision allowing citations to be paid directly to the State Highway Administration, and they lower the period in which the speed monitoring systems must issue warnings instead of citations from 90 to 30 days. That was actually a mistake on my part. I think we were trying to sync that up with a bill that was passed last year. I gave some bad advice, said it was 90 days when it was really 30, so I believe that was the intention of the committee on that.
Motion to concur.
Yeah.
So motion to concur, second. Is everyone okay with the concurrence? Excellent. Do we have any more?
Nope, that's it.
Okay, great. All right, let's go on to voting list 24. We're going to start off with House Bill 1017.
House Bill 1017 is an emergency bill that prohibits the state or a unit of local government from approving the construction or operation of a building, structure, or other real property for an immigration detention facility by a private entity unless the building, structure, or other real property is located in a zone that expressly authorizes immigration detention facilities. In addition, the bill prohibits a private entity from operating or occupying a building, structure, or other real property as an immigration detention facility without a use and occupancy authorization or change in use and occupancy approval consistent with the bill's provisions. There is an amendment in your packet, which is number 883925/1. The amendment essentially combines elements of this bill with the Senate cross-file, Senate Bill 984, which is already crossed over to the House. What Senate Bill 984 does is, first of all, instead of being specific to immigration detention facilities, it broadens it to include most private detention facilities. And rather than allowing them to be constructed or operated as long as there's a proper zoning, the Senate bill would essentially prohibit any kind of zoning that allows for those private detention facilities. So because the two bills are somewhat inconsistent with each other, what the amendment would do is essentially the provisions of Senate Bill 984 would go into effect immediately. And then if those provisions were challenged successfully in court and either enjoined or struck down, at that point, the provisions of House Bill 1017 would come into effect.
Just want to move the amendment, and then we can discuss the bill as amended. Is everyone okay recording the amendment? All right, now the bill's before you as amended. Discussion. Senator Folden.
Thank you. I just want to, obviously, this is an interesting bill. Because in the state of Maryland, how many private detention centers do we have, counsel? Zero. So can you explain on the record how this bill changes anything that we have in place right now? Because we have no private detention facilities in the state, so we're prohibiting approving the use. So can you tell me what problem that we currently are seeing that we're trying to resolve?
So it maintains the status quo with regard to no private prisons, which I think is a good, or detention centers, which is a good thing for a multitude of reasons, because if you operate a detention center, there should be, I think, a lot of government interaction and oversight and accountability for that practice. So that's one thing. And then two, that there are implications for situations where if there is a, let's say, and this is where the legal landscape here is murky because it's kind of uncharted water, but if you had a detention center that operated on federal land, but it was privately run, those are situations in which, you know, you're going to get in some uncharted territory with this bill.
Okay. So if it's a detention facility, say, that is leased by the federal government or leased by a state government, but leased by the government, improved upon, but it's owned by a private property, private enterprise, it's improved upon by the federal government, would that be included in this bill, or would that be excluded from this bill?
So it's okay.
So my read is what matters is who is operating the facility, who is running it. So if the federal government is doing the operations themselves, not affected. If it's a private entity who's actually running the facility, the bill would apply.
So this in no way, shape, or form would conflict with what is currently being litigated in regards to, say, like in Washington County, where the federal government has rented or leased a warehouse. They're making improvements upon it to make it a detention facility for the process of some of the immigration deportations. So this bill would not be, as written, would not prohibit that. It just prohibits any that would be done by private entities, which we have none of in the state.
So as far as I know, it's unclear at this point what the federal government's plans are in terms of who's going to run that facility. But if it decides to run that facility and operate itself, not affected. If it contracts in a private vendor to run the facility, then it would be affected.
So that's kind of the root of this then, because if they open one up, that would be what would be deemed as a temporary transition facility, and they employ private contractors, that's where this comes in.
It would apply, yes.
It would apply. Okay, thank you.
Senator Jane.
So, thank you so much, Senator Folden. That helped me, but I just want to make sure I understand. Right, we don't have any now, and actually, I thought, like with hospitals, we didn't have any because it was our policy not to have private detention or prisons or private hospitals. That's been our policy, but I guess we've never codified it, is that correct? But there's no prohibition, but I don't know how, well, it's for another day. I don't know how we telegraphed, but we haven't had them. I'm glad we haven't had them because I think they have a murky history across the country. Some are better than others. And I understand, I believe that Bill respects the understanding of the supremacy clause where it says, look, if it's the federal government owning and managing, however we may feel about it, we're not going to try to legislate in that area at this point. So what I don't know, and maybe you do and maybe you don't, has it been legislated elsewhere that when the federal government owns and or leases, but then brings in third parties? Because I'm just thinking there's a lot of federal employees that are really government contractors. Oftentimes they do great work, because my husband did that for years before he became a real behind-the-gate person. But do we have cases that say anything about that situation? What I'm trying to figure out is, when does the federal government cross the Rubicon to the protections of the supremacy clause? So they buy the land, they build the building, They create the structure by which the building will be managed and operated, but then they bring in, unless it's a government employee, then even if they have third-party contractors, that's where the bill would apply? Or is there some wiggle room in there, or are we that specific? Multiple questions, but maybe you followed me.
The situation you're describing is most recently litigated in California.
Is it California?
And there were 2 points of question there. One was whether you were discriminating between the government and private entities, or whether you're basically treating the government different. So, and then the second was the supremacy clause
Right.
piece,
Oh, yeah, okay.
and whether that created some sort of a federal enclave. So the second piece, the first piece, it said, hey, California, since they applied it broadly, did not discriminate against the federal government. But
Right.
the second piece, it was viewed that, and counsel correct me if I'm wrong, I think it was viewed that it did infringe on government operations such that it violated the supremacy clause.
And the second one is what now? What did they
It's when
do?
you had the government owned facility,
Yes.
but a privately run piece.
That violated the supremacy clause?
No, they're banning it. Is that
So it
what?
was government owned and run, but,
Run?
sorry, government owned but privately run. That was violative of the supremacy
What
clause.
I'm trying to figure out is, and
In that-
maybe I'm
in
getting
that
too much
case.
into the weeds, but, there are government created programs and buildings, and then the government creates all the rules and regulations, da, 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 da. But for whatever money saving, they might have a third party come in and, technically follow all their rules and regulations. Does our bill touch that, or is it more like, and this is very different, there's a hands-off situation?
It could potentially, but again, it's broadly applied, but it would apply there, and I would assume that a legal challenge would ensue.
But
You
it-
would then have, a Fourth Circuit versus Ninth Circuit, so if there's a split in circuits, then you're obviously going to go to the
Right.
Supreme Court, and, we'll continue to figure out
But
where.
we would also, that same thing would also apply if the state tried to get around its own law too, right? We wouldn't allow under this bill, the state to own, build, and then bring in that third party because it violates the spirit of the policy that we don't want private people, private entities
Which we can clearly
involved in
do.
this, right?
Which we have the prerogative to do here in the
That's right.
legislature, for sure.
Okay, that helps, thanks.
Senator West.
Thank you, Mr. Chair. So I am comfortable with the idea that in the state of Maryland, there should not be privately operated detention facilities. But I'm looking at the bill, and what the bill says, I'm looking on the reprint on page 2, down in the middle of the page, subparagraph B, it says, the state or unit of local government may not approve the construction of a building by a private entity. Now, my understanding is when the state decides to build structures, it doesn't build the structures itself. It contracts with private entities to build the structures. And as I read this bill, it would prevent the state of Maryland from contracting with a private entity to construct any future detention facility. For example, we just approved a couple of weeks ago, a bill I voted against, to construct a very expensive detention facility in Baltimore City. I'll guarantee you the state of Maryland is not going to itself construct that detention facility. It will contract with a private company to build the facility. And as I read this bill would preclude a private company from building that facility. Am I right on that?
Senator, the way I would read that provision, it says, the state or unit of local government may not approve the construction or operation of a building, a structure, or other real property for a detention facility by a private entity. It's maybe not the most precise wording, but the by a private entity is modifying the for a detention facility. So it's saying you may not approve the construction or operation of the building or structure to be used as a detention facility operated by the private entity.
Why
Not that the
don't we
private.
make that statutory change so it's clear, rather than leave it ambiguous?
That's fine.
For.
That's not the way I read it. So if I could read it the wrong way, other
Sure.
people can too.
So looking at it, perhaps it would say a building structure, other real property for, and then say for operation as a detention facility by a private entity.
More clear.
How about which would be used, or which is intended to be used for a detention facility by a private entity? Or something like that?
Construction or operation of a building, a structure, or other real property to be used as a detention facility by a private entity?
Yeah.
Okay.
Well, why don't we say to be used by a private entity as a detention facility? That would make it clear that the by a private entity modifies the terms as a detention facility.
Okay, and I think there would probably need to be a corresponding change.
Yeah, in the second part of the bill, too.
Yes.
Exactly.
May not approve, yeah, so you would be making the same change on the unnumbered page after page 2 of 3 in the similar section B, subsection B1 there. Yeah, so it's on page 2 of the reprint, it's unnumbered lines, but in subsection B there, that would read, may not approve the construction or operation of a building, a structure, or other real property, and then strike the rest of it and substitute to be used by a private entity as a detention facility. And then there would be a corresponding change on the next unnumbered page in subsection B1.
That's fine. Is everyone okay adopting that amendment? Sure, Senator James.
For Wes for picking up this ambiguity. But and I don't know the answer to this question, but I've not seen us try to legislate what gets constructed, because I don't think that local governments oftentimes legislate about the ultimate purpose of a building. It's whether the construction of the building, I mean, you can talk about how many bathrooms and lights it needs, but I'm just trying to make sure that we're on, I want this language to work, but why are we even getting into the construction of the building when what's important to us is who would operate it? So, I mean, do we need to be discussing construction when what we really care about, and what I'm thinking about is just getting into the mess of due process, vested rights, local zoning, and the like. But if you tell me that we do need to talk about construction as well as what's buildings used for, then just explain that to me and I'll be supportive. But I'm just not sure why we're into the construction of the building. Unless you're worried on the other end, we don't want somebody to go down the road of starting to construct something, believing they may use it for something. We want to get them early on so they don't argue vested rights. I don't know if this was thought through or not. Just from a zoning, how do you deal with restricting uses for when we want to keep things public for prisons and hospitals? That's all.
No, I mean, I think if you know that you're going to construct a facility and it's your constructed facility that's going to be privately run for the express purpose of having it as a detention center, I think that's what the language speaks to. And I was just talking to council about retrofitting or things like that.
Right.
But if you are trying to get that permitting process for a detention center, I think that's where the language is really trying to cut that process off at the.
I guess to give them as early a warning as you can would be the only way I can argue against my own worry. Okay, thank you. Okay, thanks.
We can do, there's a motion for a favorable. It's been seconded. We're going to do a roll call.
Vice Chair Waldstreicher.
Yes.
Senator Sidnor.
Yes.
Senator West.
Yes.
Senator Muse.
No.
Senator Folden.
No.
Senator James.
Yes.
Senator Henson.
Yes.
Senator Love.
Yes.
I can't. It's not, it stopped working.
Press your button. Can you turn hers off and then?
I can't. It won't let me turn anything on or off. Oh, there we go. Senator McKay,
No.
Senator Charles,
Oh, keep it there for a second. All right. There you go.
Chairman Smith,
Yes. All right, House Bill as amended passes 7-2. We'll now move on to Shamari with House Bill 963.
House Bill 963 repeals a prohibition against letters of administration which authorize a personal representative to administer an estate being granted to a person who is not a citizen of the United States unless the person is a permanent resident of the United States and is the spouse, an ancestor, a descendant, or a sibling of the decedent. There is an amendment in your packet. Actually, I may have not included that, but I can describe it. You do have it, okay. Where's my copy? And so the amendments, if you look on page 2 of the reprint, it reinserts the language that was stricken in the bill originally and instead states not a citizen or a permanent resident of the United States unless the person is domiciled in the United States and is the spouse of the decedent, an ancestor of the decedent, a descendant of the decedent, or a sibling of the decedent.
All right, just move to adopt the amendments. Okay, is everyone okay? All right, now the bill is before you as amended. Senator Folden.
Thank you, Mr. Chair. So this is just taking and striking out the brackets, right? Section 4, or I guess it's page 2, line 15 through 20. Is that what it's doing, deleting that? Can council tell me when the original bill was crafted? That included this language?
The amendment has a date and time, but I'm not sure when the original bill is
No, I'm not talking about the amendment. I'm talking about this bill, before they decided to bracket out, as it was written. I want to know where and where, like.
The underlying law is what is bracketed, the current law.
Yeah,
And so the original bill struck that part of the law.
So the current law, when was it enacted?
I can look that up and probably get back to you.
Just, I'd like to know. I mean, I'm trying to compare where the mindset is that we have a law that we've created, and then we come and bracket out a certain specific area with a very specific intent on the heels of other discussions that we've had, and we're seeing this whole swing and of the pendulum, and I'd just like to know when that was initially crafted and why. I mean, now all of a sudden we're deleting this.
I can probably take a quick look and try to see if I can tell what year was added to the code, but as to why, I'd have to see the bill file.
Okay. Thank you.
Thank you, Mr. Chair. To Senator Folden's question, I don't know when it was originally drafted, but in case you don't recall the testimony, the bill was drafted after the accident with the dolly, when someone was killed, and his widow could not probate the estate. So that's what it's trying to help. So it's actually separate and apart from so much of what we're talking about. Sure.
Amended. Right.
All right, there's a motion for favorable with amendment. It's been seconded. Do we need a roll call? Okay. Everyone's good. House Bill 963 with the amendments passes unanimously? Yes, all right. All right, we're now going to go on to House Bill 1062.
House Bill 1062 specifies additional transactions that a circuit court may authorize or direct with respect to the property, service, or care arrangement of a minor or disabled person without appointing a guardian, under circumstances in which the court otherwise could appoint a guardian of the property, to granting access to financial records and establishing eligibility for government assistance programs. There are no amendments.
Motions for favorable, it's been seconded. Is everyone okay being recorded in the affirmative? House Bill 1062 passes unanimously. All right, we're now going to go on, Jamie, with House Bill 1441.
There it is. Thank you, Mr. Chairman. House Bill 1441 authorizes an adult individual issued a citation to prepay a fine for violations of Section 6321 of the Alcoholic Beverages and Cannabis article, or 6332 of that article, which pertain respectively to consumption of alcoholic beverages in public and possession of an open container. Prepayment of a fine must be considered a guilty plea to the violation. The chief judge of the district court must establish a schedule for prepayment of fines. A person issued a citation may request a hearing within 30 days after the citation's issuance, and the district court may require a person found to have committed a violation of 6321 or 6322 to pay the fine of up to $100. If a person issued a citation does not prepay the fine, does not request a hearing, and does not respond to a summons, the court may hold a hearing. If the evidence supports a guilty verdict, the court may find the person guilty of a code violation and impose up to the maximum fine and court costs against the person. There are no amendments in your voting packet.
So, counsel, I just want to be clear. So what we're changing is that what was normally a must appear under these citations, that they had to go in front of a judge and have a hearing because they were not of age, legal age to consume alcohol and or cannabis, that we're now making this a prepayable? With
Right up to the point where you mentioned that it was not of age. So this was open container violations and.
Oh, so.
Right, so it didn't have to do with the underage aspect of it. This makes it prepayable for the adult.
Okay, thank you.
I don't think I was here for this hearing, so can you help me out? You're prepaying before you go out with, I mean, how does this work?
So prepayment works based on there's a set schedule for prepayment for certain offenses that's set by the chief judge of the district court. A good example is that, unrelated to this, you'd have a speeding violation. You don't always have to stand trial or appear in court for that violation. You could prepay based on that prepayment schedule that the district court judge had, or chief judge had come up with.
Okay, so it's prepaying prior to trial.
Right, so
okay.
it's an acknowledgement of guilt by paying the ticket. So if any of us are driving home this evening and get stopped, on the way home, maybe get a speeding ticket. If it's just a speeding ticket, there would be that option to prepay the ticket as opposed to having to appear in court to contest it or plead guilty.
Gotcha. And this is just there's no jailable time or anything for something like this? Okay.
No, this would be a code violation.
Thank you.
Motions for favorable. It's been seconded. Is Evan okay being recorded in the affirmative? All right. House Bill 1441 passes unanimously. All right, we're now going to go on Shamari with House Bill 1345.
House Bill 1345 establishes that if probable cause exists for instituting proceedings, a provision in a trust purporting to penalize an interested person for contesting a trust or instituting other proceedings relating to the estate is void. The bill must be construed to apply prospectively only and may not be applied or interpreted to have any effect on or application to any cause of action arising before the bill's effective date. The bill takes effect July 1st, 2026.
Yeah, it's a good bill. Motions for favorable. It's been seconded. Is everyone okay being recorded in the affirmative? House Bill 1435 passes unanimously. Yeah. House Bill 130.
House Bill 130 establishes the task force to study deed fraud to be staffed by the Office of the Attorney General. The task force must study incidents of deed fraud in the state, including the number of complaints, resolved cases, restitution amounts, and geographic and demographic trends, study how other states combat deed fraud, identify patterns in the methods used by deed fraud perpetrators, and patterns and demographics of deed fraud victims, develop recommendations for deed fraud detection tools, conduct an analysis that identifies the economic impact of deed fraud on victims, and make recommendations for combating deed fraud in the state, including strategies for intergovernmental coordination to more effectively detect and prevent deed fraud. Members of the task force may not receive compensation but are entitled to reimbursement as provided in the state budget. The task force must report its findings and recommendations to the General Assembly by July 1st, 2028. The bill terminates September 30th, 2028. There is an amendment in your packet. Amendment 983626 provides that the Department of Legislative Services will provide staff as opposed to the Office of the Attorney General.
All right, the amendment's been moved. All right, so I have one more amendment that I'd like to add, just a small inline amendment. So since DLS is now staffing this task force. And here on it says the member of the task force, the Attorney General or the designee. I think it makes more sense to swap it to state's attorneys or a member of the State's Attorneys Association as opposed to the Attorney General. I'd just like to make that inline change. Is everyone okay with that? All right, second. All right, now the bill's before you as amended. Motions for a favorable with the amendment. It's been seconded. Is everyone okay being recorded in the affirmative? All right, House Bill 130 with the amendments passes unanimously.
Sorry to, a member of the Maryland State's Attorneys Association? Okay.
Now we're going to go on to House Bill 200.
House Bill 200 requires, subject to specified exceptions, and beginning July 1st, a seller of real property to provide flood risk information to a purchaser before the parties enter into a contract. The requirement only applies to residential real property improved by 4 or fewer single-family units. By June 1st, 2027, the Maryland Department of the Environment must develop and publish a real property flood risk disclosure statement form for use in connection with the bill's requirements. There are no amendments.
All right, it's been a motion for or favorable. It's been seconded. Is everyone okay being recorded in the affirmative? Yeah, just take your time.
Commonly, I've heard of like the 100-year flood zone plan. I've never heard of a 500-year flood plan. I mean, what is, so are they being required to do both those? And like, are they having to pay more for that? I'm just trying to be clear on this. I've never heard of a 500-year flood plan. I mean, the only person here that might even remember that would be Senator West.
Yeah, I wanted to do it.
I meant to say Muse. I'm sorry, I'm sorry, Chris. I'm sorry. I'm sorry. I'm sorry.
I'm sorry.
I just wanted you to wake up.
Only for 2 minutes. I'm going to sleep in about 60 seconds.
I'm zinging them. I'm zinging them. Yeah.
So I'm just looking, and FEMA does have definitions of flood zone designations, and
So what I'm asking is I know you're saying that they have designations, but this bill wants to require people to notify someone if they're selling a home that they live in a 500-year floodplain?
so they just have to make the disclosure, give the disclosure. I don't believe the bill requires them to find out. Just let me look really quickly.
So I guess whose responsibility is it to notify a seller that they live in a 500-year floodplain?
So just looking at the bill,
Yeah, I mean,
a completed flood
that's what I'm looking at.
risk disclosure statement form developed and published by the Department of the Environment under 5-810. And a
Understand.
copy of the FEMA elevation certificate for the property. So I think the seller would just probably find out from FEMA under the bill.
So the FEMA definition of the 500-year plan is not like actual 500 years. So it says the plan is the 500-year flood plain or 0.2 annual chance of floodplain is the area with 1 in 500 chance of being flooded in any given year. And it's a designation by FEMA. So it's not 500 years in time.
Okay.
And so it's a risk level
So
assessment.
Chris wasn't the only one that's been around.
So I guess we've all been around for that.
Okay.
Yeah.
So thank you for that. So I guess then there's a, FEMA puts out the certificate. So who is it, does it say in there whose responsibility it is then to disclose it? Is this something, like, I'm just asking, are we putting this on realtors? Are you putting this on the settlement companies? Are you, like, whose responsibility is it? The seller?
A vendor of residential real property. So it's on the seller under the bill.
So a vendor on real property, so is that the settlement, or is that the settlement company, or is that the attorney? Or I'm sorry, or the realtor?
So the seller through their agent, through their realtor would have to provide it. And there's similar disclosures that are required. We did the Superfund bill a couple of years ago. So
We add a lot to it. And I'm sorry, Mr. Chair, just one brief second. Just an indulgence here. Trying to read through a lot of bolded print.
So it seems as though, I mean, if this is part of the normal transfer and sale, like, it's right, I mean, I'm looking at the fiscal note. I mean, obviously the government impact is very low. Local government impact is low. And then it says the impact for small businesses is minimal. So it seems as though
It's just
acquiring the
it's just something
certificate,
else.
it is an additional piece of paperwork that you're gonna have to acquire and file, but when they've consulted all the stakeholders, small business came in and said, look,
I understand.
small impact.
I appreciate it. I'm done with my questions. I just wanted to ask. Thank you.
So I got the same concerns. I'm not sure they've been satisfied. So the form, which is provided for on page 2 of the bill, requires disclosure of whether the property is located in a special flood hazard area. That's the 100-year floodplain. Also, whether the property is located or within a moderate risk flood hazard area. That's the 500-year floodplain. Now, in my legal practice, I remember 100-year floodplains, and the maps are published. Somebody who does this work can get a hold of a published map, which would show whether a particular property is located within the one. I am not familiar with published maps showing 500-year floodplains. If someone on the committee is familiar with that, if that's easily available, I don't have a problem. But if it's not easily available, I don't see how a homeowner can be charged with filling out a form as to whether the property is within a 500-year floodplain or not.
Mr. Costelli might have the answer. William?
Hey, Bill Castelli on behalf of the Realtors, and there is a website that you can go to, you put your address in, and it will tell you, give you a picture of your property boundary, and it'll tell you whether you're in or out.
Within a 500-year floodplain?
Yep, for both of the qualifications that are in the bill.
Okay, thanks. That answers my question. Appreciate it.
What's the difference between 100 and the 500?
It's about percent of what your risk is. So one is, I think, 0.2% risk. Yeah, that's the 500-year
Yeah.
one.
And your risk goes up, or I guess it goes down a little with the shorter period, right?
Yeah.
Right. Yeah, and we do 1,000,000 years, I mean, eventually, we're all gonna get flooded. So, there you go. Let's just tell everybody that.
So while he's up there, while you're up there, I mean, who's the beneficiary of this besides insurance?
Purchaser, when the purchaser's coming and wants to know, especially if there's been a flooding event on the property.
Especially, yes, it's for who's purchasing it, but because this gets reevaluated like every 20 years or something like that, and because it's a fund that the federal government is putting the money into, when that is scheduled to not have enough money in it, then they move the boundaries. And down along Georges Creek, we were actually adding the school, which is on a hill, into the floodplain, which made no sense whatsoever. But yet, because of the actuarities or the math, they ended up putting that into the floodplain, which then would make a difference for someone purchasing it to understand that now they're going to have the rate higher.
Sure.
Yes, sir. Whatever Senator Folden just said, I'm with him.
All right, so we've got a motion for a favorable. It's been seconded. Yeah, it's favorable with the amendments. All right, all right. Folden's down. Is everyone else okay being recorded in the affirmative? Excellent. All right, we're going to go with House Bill 1311.
1311? Yeah. House Bill 1311 requires the Department of Public Safety and Correctional Services to assist incarcerated individuals in accessing state student financial assistance, in addition to the current law, which requires them to assist in accessing federal Pell Grants. The department would consult with the Maryland Higher Education Commission, in addition to the current requirements, which require them to consult with the commission regarding Pell Grants.
Motions for favorable, it's been seconded. 1311. So there's been a motion for favorable. All right, it's been seconded. We've got one down. We're doing it right now. Okay. Okay, so 9 to 1. All right. House Bill 1311 passes with 9-1. We're now going to go on to Shamari with House Bill 1305.
House Bill 1305 requires the Maryland State Department of Education to annually report to the General Assembly and the Department of Human Services on the number of foster youth who enroll in college and graduate within 6 years. In reporting this and other information regarding children and foster youth in the state child welfare system per current law, MSD must include, where appropriate, comparison data for children and students not in the state child welfare system. Further, by December 1st, 2026, MSDE, in cooperation with DHS, must develop and submit a report to the General Assembly on improving outcomes for students in the child welfare system.
1305. All right, motions for favorable, it's been seconded. Is everyone okay being recorded in affirmative? All right. House Bill 1305 passes unanimously. All right. Shamar, we're going to stick with you for a little bit. We're going to go to House Bill 281.
This emergency department bill generally alters statutory provisions related to criminal background investigations for specified individuals who care for or supervise or otherwise have specified access to children, including provisions that govern the process for the dissemination of criminal history record checks. There is no amendment in your packet, but there is a small technical amendment requested by the department. And if you look on page 6 of the bill, line 14, we're just striking, this is HB 281, page 6. Line 14, it's one word, we're striking provides and substituting conduct. This was a request from the department and the FBI. According to the FBI, the word provides is problematic as it infers delivery of the fingerprints. Applicant fingerprints must be submitted to the FBI within 15 calendar days from the date the preliminary name check is conducted.
Amendment's been moved, it's been seconded. Now the bill's before you as amended. Senator Love.
Chair, Shamara, I just have a question about page 3, subsection 8. Is this saying that, so I'll give you an example. My neighbor had to go in for surgery out of state. Spouse went along. Children were left with a neighbor. So now, do those neighbors have to have a criminal background check?
So my read of this is that that would be accurate.
And who would request that?
My wife and I call that vacation. I mean,
Not sure about that, Senator. I can try to get an answer for you. How
That would be great.
works.
That's a great question. That is a great question, Senator. And no, that actually only if they're in foster care. And there are other family members that are coming in to relieve the guardians. Would that have to take place?
Got it. Thank you so much.
You're welcome.
All right, so there's been a motion with a favorable with the amendment. It's been seconded. Is everyone okay being there was a small amendment that he added in. Okay. All right. Is everyone okay being recorded in the affirmative? All right. House Bill 281 with the amendment passes unanimously. All right, we're going to go with House Bill 776.
House Bill 776 establishes that if a law enforcement officer alleges the commission of an act by a child younger than age 13 that results in the death of a victim, the law enforcement officer must forward the complaint to the Department of Juvenile Services for appropriate action, which would be a child in need of supervision petition. If a intake officer receives such a complaint, the intake officer must file a petition alleging that the child is in need of supervision with the juvenile courts.
All right, Senator Fulton said he's up on that, but I'm sorry, there's no question. Yeah, no. There's been a motion for a favorable. It's been seconded. Is everyone okay being recorded in the affirmative? Senator Fulton stepped out to take a call, but he's recorded in the affirmative on this as well. All right. All right, so House Bill 776 passes unanimously. So that'll be the last bill that we vote on for this voting session because we've got floor in 20 minutes. It looks like we will be coming back for a brief voting session after the floor. I apologize to do that to you, but we have two bills that we have to deal with directly after floor. So we'll be coming directly back here. The sooner we get here, the sooner we'll get out of here. So please come directly from the floor to JPR after we gavel out on the floor tonight. I don't know. All right, see you all in a bit.